So we're starting at Henry III, who apparently regained Kenilworth Castle after King John had lost it. Important early constitutional legal rulings. Henry III. In the reign of Henry III, a man called Chief Justice Henry de Bracton was on the King's bench. Bracton's rulings are so important that they are still taught at law schools today. He said that the King is beneath no man, but he is beneath God, and rules England as God's lieutenant and according to God's laws. And he is beneath the law, for it is by the law that he becomes king. This judgment imposes constraints on the sovereign, so that he cannot act unjustly. Another of Bracton's rulings is, the laws of England, having been approved by those who use them, and having been confirmed by the oaths of kings, cannot be changed or disposed of without the common consent of those by whose counsel and consent they were promulgated. For those who are unaware, our forefathers established the principle that it is the English people who must approve any changes to our laws, and this principle has been handed down to us. In England, we have the rule of law. Unjust laws are not laws. In 1345, Chief Justice Stoner, I hope I've said his name right, said, "Law is that which is right." In the second half of the same century, Judge Hilary said, "We will not and we cannot change the ancient usages." Chief Justice Beresford said, "You should not only look at the letter of the law, but at the spirit of the law." Beresford also said, "There is no such thing as a bad law, for if it is bad, it is not law. It is to judges like these that those good sound principles espoused by the common law of England owe so much. Englishmen have had just cause to feel safe under English law. King Edward III issued the Statutes of Treason, Provisors and Preaminuire 1351. I always don't know how to say that word. Preaminuire. I say Preaminuire, that's how I say it. So King Edward III issued the Statutes of Treason, Provisors and Preaminuire 1351, which is still on the statutes today. These were anti-papal laws which were designed to keep foreign interference out of England. The Act of Provisors forbade the selling or gifting of any English asset to a foreign owner. This was because people, in an effort to save their souls, were leaving property to the local abbey, and the abbey was transferring ownership to Rome. This meant that there were parts of England where the new owner, the Pope, did not accept authority of the King of England. The ultimate legal defence of the crown and realm depended on the treason law. So we're going on to Edward II. We finish up with the treason law. So many people in our group have been asking, does these laws cover? The law is for the Commonwealth. So we've got England's constitution, England and the Commonwealth. So that is Scotland, Northern Ireland and any other country in the Commonwealth, apparently. I find that part interesting because we fought the water board. You can read those case files, and we argued that it is illegal to actually give our services over to corporate to make them private. But anyway, you can read about that. There you go. Edward II. Edward II was deposed here in Kenilworth Castle. He was kept captive after being caught in South Wales, apparently, by his queen. And her lover deposed of him. Edward II was another king who thought he could do as he liked. He was lazy when it came to his duties as king, and he had his favourites who almost seemed to get away with everything. This caused the barons to remove Edward, who was forced to resign his crown in favour of his son. He was then killed, allegedly, in Berkeley Castle in Gloucestershire with a red-hot poker up his back passage.
Yikes.
Yeah. Edward III. In 1366, Edward III received a letter from the Pope demanding 1,000 marks a year for every year that it had not been paid, and threatening action if the monies were not received. Edward III spoke to the bishops and the lords, who spoke to the commons. First the bishops, then the lords, and finally the commons came to Edward and told him that England had not been King John's to give away. Under English law, John had only held England in trust for his successors, and therefore the agreement between the Pope and King John was not valid. By giving England to the Pope, John had broken the law. The money was not owed and should not be paid. This major constitutional ruling ensures that England's sovereigns were not and can never be vassal kings to anyone. This is a most important constitutional ruling which applies as much today as it did then. And we move to today, when John Major came back from Maastricht and said the Queen was now a citizen of Europe. He attempted to destroy a constitutional principle that our kings can never be vassal kings to anyone. John Major had committed the major crime of high treason. King Edward III also claimed the Kingdom of France. Parliament made him sign an undertaking that, as King of France, Edward could have no say in how England was governed. In 1351, King Edward III issued his Act of Provisors, which prevented the transfer of any English asset to a foreign power. Now, I know my waterboard was owned by a French. Anyway, getting carried away. He also issued his 1351 Act of Preaminuire, which forbade the imposition of any law on England by a foreign power, the drawing out of England any of his subjects to be tried in a foreign court, and the excommunicating of his subjects by the bishop on the orders of the Pope. All these things King Edward III considered an affront to his honour and dignity as King of England. These crimes were akin to high treason. The Act of Provisors was repealed by the 1948 Criminal Law Revision Act. The Act of Preaminuire was repealed in the 1967 Criminal Law Act. Both these great laws were repealed by Labour governments, albeit illegally, no doubt. So, the drawing out of any England to be subjects to be tried in a foreign court. So, no court should have supremacy over English courts. That makes me think of the ECHR. There you go. I should just read this, really, shouldn't I? Richard II. In 1392, King Richard II issued his Statute of Preaminuire, which forbade the imposition of foreign law on England and the drawing out of England and the king's subjects to be tried in foreign courts, breaches of which amounted to high treason. It was repealed in the Criminal Law Act 1967, just in time to prevent Edward Heath's government committing a Preaminuire by placing Her Majesty's courts under the dominion of the European courts and allowing foreign law to have effect over English law in England. I asked the Law Commission why this most important statute of Preaminuire had been repealed. The reason given to me by the Law Commission was that the law had not been used for many years, and so they inferred it was obsolete. Yet there is no such thing as a principle of obsolescence in English law. Who is to say that it had not been used? Because, like all law, it's designed to prevent crime. By preventing treasonable crimes from being committed, King Richard's statute had worked very well. I apologise for not knowing how to pronounce that word that keeps being used again and again and again. We're going to do the Tudors, and then we're going to stop because we're going to get to the Stuarts, and we're going to go over to Edgehill, where the first ever battle was it, Civil War. Yeah.
First major engagement, yeah.
First major engagement, and so we're going to be moving on to the Stuarts after the Tudors and moving on to Edgehill. So the Tudors. Under King Henry VIII, we see the final parting of the ways between the Roman Church and England. The 1351 Treason Act remained the predominant Treason Act. King Henry issued his Act of Supremacy, 1534, making him Supreme Governor of England in all things ecclesiastical. In spite of this, King Henry VIII was an arrogant bully who ruled outside the law, and it was Henry VIII, trying to distance himself from the murder of his wife on an invented allegation of treason, instructed his assent to her execution to be given by a commission of peers. This was illegal, and the assent being only in the hands of the king. During the reign of Queen Elizabeth I, the Pope attempted to have the Queen murdered. He said that whoever killed her would not suffer, but would receive both earthly and heavenly rewards. Queen Elizabeth was understandably far from amused by this, and she reissued her father's Act of Supremacy in 1559. This act contained an oath, part of which states, "No foreign prince, person, state or potentate, or hath or ought to have any power, jurisdiction, superiority, supremacy, or authority, ecclesiastical or spiritual, in this realm." The Tudors, on the whole, ruled according to the prerogatives given to them by law. So that's a major one, the Act of Supremacy. No foreign prince, person, state or potentate have or ought to have any power, jurisdiction, superiority, supremacy or authority, ecclesiastical or spiritual, in this realm. And that starts to this day. And I'm sure that probably includes any world hoax organisations. Or I hope you've enjoyed this reading. There's so much more to look at in our files, which I keep trying to interject to talk about, which includes our case files. So if you're confused about anything I said during the reading, please check out our files and see the case files we have, which have all these laws and different laws written into the evidences at the back of them. We really like this spot. It's really beautiful at Kenilworth. You look around at the woods and everything, and the bluebells out today. We hope you're all having a lovely weekend, and thanks for tuning in. We're moving on to Edgehill.